Arbitration is on the move. We can wonder why. First, globalization. Is it not better to settle a dispute between a Portuguese and a Chinese company through arbitration? Second, digitalization. Can our digital world bring new opportunities for arbitration? What says the law on arbitration? First, I will discuss with you the advantage and disadvantage of arbitration. Second, I will see with you the different kinds of arbitration. Third, I will see some words on the content of an arbitration clause. And fourth, we will see the aspect of digital arbitration. What are the advantages and disadvantages of arbitration? First advantage, party can choose their own judge. They can choose their own judge in function of their competence in a certain technical field, or they can also choose the arbitrators they can trust. And trust, as you know, is very important for a dispute. Second point, arbitration is faster than litigation. You can have an arbitration award within a period of 6 months, but if you go before the court, maybe you have to wait for 3, 4, or 5 years before having a definitive judgment. 3, confidentiality. Arbitration takes place in a closed room. That means that banking or business secrecy are protected. 4, language. If you have a case in Belgium, you are obliged to go in Antwerp and to introduce your case in Flemish. If you go in Liège, you have to introduce your case in French. The language is free in arbitration, and most of the arbitration takes place in English. Fifth, it is easier to enforce. Thus, the New York Convention on Enforcement of Arbitration Awards is recognized all over the world. That means that if you go in China, you can use the New York Convention to enforce the arbitration in this country. What is the disadvantage? The main disadvantage of arbitration is the costs. The costs are something high because you have to pay your own judge, what is not the case before ordinary courts. What are the main kinds of arbitration? Institutional arbitration and ad hoc arbitration. Institutional is an arbitration which is entrusted to a specific arbitration institution. I can give you 2 examples. ICC, International Chamber of Commerce, the Court of Arbitration has a very high reputation. That means that the case manager of the ICC follow up your procedure, the proceeding of the arbitration. And secondly, they supervise also the quality of the work of the arbitrators. In the case of the CEPANI, that's also an institutional arbitration. It's also a case manager who follow-ups all the case. And in both cases, there is a revision of the quality of the arbitration awards by the institution. On the other hand, we have the ad hoc arbitration. In this case, the arbitrators are free. They have only to stick by the arbitration clause and also by the rules of the judicial court. When you draft an arbitration clause, you have to pay attention to 3 problems. First, the number of arbitrators. I advise you to take an hot number of arbitrators because when you have 2 arbitrators, it's maybe difficult to find a solution. Second, the seat of arbitration. Why is it important? Because the procedure rules are the rules of the seat of arbitration. And third, the language. I already explained that language was very important. Thus, you can choose your own language, but it must be mentioned in the clause. It is anyway better. I think it's important to see that our digital world offers new opportunities for arbitration. There are two good examples I can give. First, e-justs. That means that the European Commission has offered specific means to settle dispute, to digitalize arbitration. That's first, very important. Second, more specific example, in case of documentary credit, there is a new dispute resolution means online, DocDex, and when you have a problem in this very specific field, you can use this specific way of dispute resolution to settle your case. Through this presentation, we see that arbitration is really on the move. We saw that arbitration is very efficient and very flexible. And I want to stress the digital arbitration. We see that through the initiative of the European Union, through the initiative of the International Commercial Court, digital arbitration is a reality. If you want to have more information on this, I invite you to have a look at our website, philippelaw.eu.